Good afternoon. I'm going to be presenting this afternoon on the WHO Framework Convention on Tobacco Control and the legal challenges to tobacco plain packaging. It's around 2 years since the last Oceania Tobacco Control Conference. I spoke about the challenges to plain packaging at that conference. That was in October 2013, and I've gone back and had a look at the slides that I used then. And this slide captures the situation in October 2013. The High Court constitutional challenge to plain packaging was long finished, resolved 6-1 in favour of the Australian government, and we were waiting on outcomes of the international legal challenges, both in the World Trade Organization and under a bilateral investment treaty. Fast forward 2 years, and you'll see the latest update in October 2015 is that the High Court constitutional challenge is long finished, 6-1 in favour of the Australian government, and we're waiting on the outcomes of the international challenges in the World Trade Organization and under a bilateral investment treaty. So while on those slides it might look like not much has happened, that's not the case. There has been significant progress in both of those sets of challenges. But we know that litigation can move very slowly, and particularly when one side has an interest in prolonging it. And we all know that the tobacco industry and its friends have had an incentive all along to drag out the challenges to plain packaging in the hope of dissuading other countries from moving forward. In the WTO challenges, this is the state-to-state dispute settlement system. So it's countries against countries. And here there are 4 countries that are claiming that Australia's plain packaging breaches Australia's obligations under the WTO. The main claims being made are that plain packaging is more trade restrictive than necessary to fulfil a legitimate objective. That's a claim being brought under the Agreement on Technical Barriers to Trade. And claims relating to the encumbrance by special requirements on the use of trademarks in the course of trade. These are claims being made under the WTO TRIPS agreement. The panel was appointed to adjudicate on the complaints in May 2014, and we are well into the process now, though the panel has advised that it won't issue its report until the first half of 2016 at the earliest. The panel's report can then be appealed by any of the parties to the WTO's appellate body. So the expectation is that the WTO complaints still have quite a way to run. Significant development occurred in May 2015 when Ukraine, one of the 5 original complainants, indicated that it was suspending its challenge and it's proceeding to withdraw it entirely, leaving 4 countries, Cuba, the Dominican Republic, Honduras and Indonesia, as complainants. And there's a record number of third parties in the disputes, 41 parties, including the complainants. Third parties are able to make submissions in the proceedings, either for the complainant, against the complainant, or on points of law. And the record number of third parties shows the enormous international interest in these cases and their significance for public health and for the way in which the WTO system leaves room for countries to regulate in the public interest in general. In the other international legal challenge, this is the one taking place under a 1993 bilateral investment treaty between Australia and Hong Kong. This is so-called investor-state dispute settlement, ISDS, which has become very prominent in public debate in Australia and New Zealand, particularly in the context of the Trans-Pacific Partnership Agreement. The main claims being made here are that plain packaging expropriates the property of a foreign investor, and that Australia's plain packaging fails to afford foreign investors fair and equitable treatment. Where we're up to in this proceeding is that in April 2014, the Tribunal granted Australia's request to bifurcate the proceedings. This means that the Tribunal is hearing Australia's jurisdictional objections first, and only if these objections are unsuccessful will the case proceed to a hearing on the merits. Australia's jurisdictional objections relate to the fact that Philip Morris Asia acquired its interest in Philip Morris Australia on the 23rd of February 2011, that is 10 months after plain packaging had been announced. The hearing of Australia's objections on jurisdiction was held in February 2015 in Singapore, and we're awaiting a decision as we speak. If the Tribunal finds in Australia's favour, that will be the end of the dispute. If the Tribunal finds in favour of Philip Morris Asia, we'll then proceed to a hearing on the merits. So you'll see that these are very long processes. Plain packaging announced in April 2010, legislated in November 2011, fully in effect in December 2012. We're now almost at the end of 2015, and both sets of cases are still running. So what about the merits of the claims? Well, the position remains as it was in October 2013. The Australian Government is confident in its position. The overwhelming majority of expert opinion expects Australia to win in both fora. And in my opinion, in the opinion of the McCabe Centre, Australia's law is a sound exercise of its sovereign power to regulate. It's non-discriminatory, based on evidence, and well drafted. And importantly, it has behind it the legal and political force of the WHO FCTC, its Article 11 and Article 13 guidelines, other decisions of the Conference of the Parties to the Treaty, and other international instruments, including the Doha Declaration on TRIPS and Public Health. And there have been a number of significant developments since 2013 as the legal cases have been proceeding. Particularly significant one is other countries moving towards plain packaging. And I'm sure you'll have been discussing this through the conference, that although some countries have been dissuaded by litigation and threats of litigation, a number of other countries are moving forward, Ireland and the UK being the furthest advanced. The ongoing development of evidence in support of plain packaging, and again I'm sure you'll have been discussing the evidence of the early impacts of plain packaging through the course of the conference. The continuing development of legal scholarship on WTO law, investment law, and on the legal significance of the Framework Convention on Tobacco Control. These are still relatively new fields, and the ongoing cases have really focused the attention of legal scholars who've produced excellent and really significant scholarship on the relationships between these different areas of international law. More generally, there's the ongoing increase in knowledge and capacity on these relationships between health, the Framework Convention on Tobacco Control, trade and investment across different sectors of government. So not just lawyers, but people working in health policy, people working in foreign affairs and trade. Government's ongoing cooperation through the Framework Convention on Tobacco Control. The most recent session of the Conference of the Parties was held in October 2014. The COP was again engaging with these questions about the relationship between FCTC implementation and trade and investment law, reasserting the importance of moving forward and not being dissuaded by tobacco industry threats of legal challenges. And most recently, the inclusion of non-communicable diseases and tobacco control specifically in the new Sustainable Development Goals, which were adopted in New York at the end of September. Inclusion of tobacco control and non-communicable diseases in the global agenda in this way sets a really important framework for global governance broadly, and puts what's at stake in these cases into their real global context. So that's what I wanted to say this afternoon as an update on the legal cases. Sorry I wasn't able to be with you in person. Please do get in touch with me, with the McCabe Centre, if you have any questions or queries. Thank you very much.